In today's The Hindu, it has been reported that Supreme Court has declined to commute Balwant Singh's death penalty. Balwant Singh was awarded death sentence for the assassination of former Chief Minister of Punjab, Bein Singh. Similarly, Supreme Court has questioned the decision of Gujarat government to remit the convicts in Bilkis Bano case. This is known that the people who were found guilty for the gang rape and murder of family members of Bilkis Bano were convicted by a special court in Mumbai after the case was transferred from Gujarat to Maharashtra. Last year, Gujarat government has used its powers under Criminal Procedure Code to remit the sentence of these 11 convicts. In context of such news affairs, we often come across terms such as remission, commutation, respite, and even the pardoning powers of President of India and governors. To understand these news items, we should have a factual as well as analytical understanding of these concepts. We will try to today understand the difference between commutation, remission, and the pardoning powers of President of India and governors of the states. At the end of the discussion, we will try to solve an MCQ or objective type question from these concepts. To understand these concepts, we will take the help of Criminal Procedure Code, CRPC, 1973, and we will take the help of the Constitution of India. Constitution of India. In CRPC, we have to take the help of Chapter 32, Sections 432 to 435. And in Constitution of India, we will take the help of Article 72, which gives President of India the pardoning powers, and Article 161, which deals with the provisions regarding pardoning power of governors of states. Let us first look at Section 432 of CRPC. It talks about the power to suspend or remit the sentences. The question here is, whose power? The answer is both the state governments as well as the central government. So the appropriate government has the power to suspend or remit the sentences. The appropriate government refers to the government or the level at which the law was enforced. That means if the law was a state law on matters where state has executive powers, then the state government will be the appropriate authority to exercise power under Section 432. Otherwise, it will be the central government. The word remit here refers to reduction in quantum of punishment. Quantum of punishment. That means, for example, a 20-year rigorous imprisonment can be reduced to, let us say, a 10-year rigorous imprisonment. That means the nature of the sentence has not been changed. Only its quantum has been changed. Let us look at Section 432 as it is given in CRPC 1973. When any person has been sentenced to punishment for an offense, the appropriate government may at any time, without conditions or upon any conditions which the person sentenced accepts, can suspend the execution of his sentence or remit the whole or any part of the punishment to which he has been sentenced. So what here we have to understand is that CRPC gives both center and state governments to remit and suspend the sentence of any convict. Let us look at Section 433. It talks about the power to commute the sentence. The word commute means to change the nature of sentence. The nature of sentence. For example, a death penalty may be commuted to imprisonment. Or let us say, a rigorous imprisonment may be commuted to simple imprisonment. A simple imprisonment may be commuted to simply a monetary fine. And again, who can do that? Who has the authority to exercise these powers of commutation? The appropriate government. Let us look at this section as it is given. The appropriate government may, without the consent of the person sentenced. It means the convict's consent is not necessary. A sentence of death can be commuted for any other punishment, or a sentence of imprisonment for life, that means life imprisonment, can be commuted to what? Imprisonment of not more than 14 years or fine. That means a life imprisonment can be commuted to penalty of less than 14 years. A sentence of rigorous imprisonment can be commuted for simple imprisonment. And a sentence of simple imprisonment can be commuted to simply a fine. Let's look at section 435. It says that state government has to act after consultation with central government in certain cases. So in certain cases, the state government can exercise its power under section 432 and 433 only with the consultation of central government. For example, cases where it's a matter of remission or commutation of sentence of a person against whom the investigation was done by any central agency. For example, the Delhi Special Police Establishment or CBI. Or where the punishment was given on matters where union has executive powers, which means the matters on which parliament has legislative powers under the constitution. Now let's look at these concepts in context of pardoning power of President of India and governors of states. We know that President of India has pardoning power under Article 72. And governors have pardoning power under Article 161. Article 72 empowers the president to pardon three types of sentences. First is sentence of death. Second, if sentence is by court-martial, that means a military court for violation of any military law, the Army Act 1950, the Indian Air Force Act 1950, or the Indian Navy Act 1957. And third, for violation of a law on which union has executive powers. Union has executive powers, which means the subjects over which parliament has the power to legislate, to make laws. Remember that this pardoning power, which is called a power of executive clemency, is not a discretionary power of the president. It is a power which is exercised on the aid and advice of Prime Minister and Council of Ministers. Having said that, it is to be noted that the personality of president and his value system will also affect the exercise of his pardoning power. For example, President K.R. Narayanan, similarly President APJ Abdul Kalam, they both were known to be abolitionists. Abolitionists are those people who suggest or who recommend for complete completely abolishing death penalty for any crime whatsoever. Now, such a president, if cannot reject the mercy petition, can at least delay the disposal of the mercy petition so that the person is not hanged. So no doubt that the pardoning power of president and governors is not discretionary power, but their personalities and their value systems, their beliefs will definitely affect the exercise of the pardoning power. The question here is, the decision of the president, is it subject to judicial review? Is it subject to judicial review? The answer is that this power comes under limited judicial review. Limited judicial review. That means the decision of the president in exercising his pardoning power can be challenged in the court only if the decision is based on any extraneous or malicious ground. For example, the caste of the convict, the religion of the convict. Otherwise, this decision of president in exercise of his pardoning power is not subject to judicial review. So the answer is that the pardoning power comes under limited judicial review of the courts. The governors similarly have pardoning powers under Article 161. The difference being that governor cannot pardon death sentence, governor cannot pardon court-martial, and governor can pardon a convict who has been sentenced for a violation of a law where state has the executive powers. Now, once this is clear, I want to make one more thing very clear. That when we say that governor cannot pardon death sentence, that does not mean that the governor cannot do anything regarding death sentence. No, let's understand what is the difference. When we talk about pardoning power, what all it covers? First, it involves completely absolving the person. It means not only whatever sentence has been given, that sentence will be waived off. But because of the conviction of the person, if he or she has suffered any disqualification, any ineligibility, even that would be waived off. It's as if the crime or the offense that for which the person has been convicted has never been committed. So this is the first option that the president has. That means completely absolving. Absolving the person. The second option in pardon is to commute. As we have already studied, commute means, for example, death penalty may be converted to, say, life imprisonment. Third option is to remit. Remit we have already seen, to reduce the quantum of sentence. For example, a 20-year imprisonment may be remitted to 10 years of imprisonment. Fourth, respite. For example, the convict who has been sentenced suffers from any special disability, or is a pregnant woman, or is mentally unstable, then the president or the governors can give some respite. Fifth is reprieve. A reprieve is especially useful when the person has been given death sentence. So when the person has been given death sentence and he files for an appeal or files for the mercy, it is to be made sure that while his appeal or the mercy plea is pending, the death sentence should not be executed. And for that, the president or the governor can give reprieve. That means a suspension of the sentence while the appeal or the mercy plea is pending. So when we say that the president has pardoning power, he has all these powers. Even governors have all these powers, except governor does not have the first option. That means the governor cannot completely absolve a person in context of Death penalty. Death penalty. Now, this will become clear once we see Article 72. Let us see Article 72. The President shall have the power to grant pardons, reprieves, respites, remissions of punishment, or to suspend, remit, or commute the sentence of any person convicted of any offense. The three cases we have discussed already: death penalty, martial law, court martial, I beg your pardon. And third is where union has the executive powers. Union has executive powers. Now, I have skipped Article 72, Clause 2. That was not very relevant. Here, let us look at Article 72, Clause 3. Nothing in subclause C of Clause 1. This is Clause 1. This is subclause C. That means Article 72, Clause 1, subclause C. It shall not affect the power to suspend, remit, or commute a sentence of death exercisable by the governor. It means governor can do what? Governor can suspend, governor can remit, or governor can commute a sentence of death. But yes, governor cannot completely pardon. And when I say completely pardon, it means the first option. This is not available to governor in case of death penalty. I hope these concepts are clear and you would be able to solve the next question, the answer of which you can leave in the comment section.